Question 1. Topic: Employment law and disability. Reasonable accommodations and undue hardship in high-stakes environment where multiple challenges arise in accommodating employees with disabilities. An employer is faced with situation involving an employee with mobility impairment. The employee requests specialized ergonomic workstation that costs $15,000. The company, mid-sized business with an annual net profit of $500,000, argues that the cost would be an undue hardship under the ADA. The employee claims that the workstation is necessary for performing essential job functions. How should court evaluate whether the accommodation is an undue hardship? A. The court will automatically side with the employer if the cost of accommodation exceeds $10,000. B. The court will assess the employer's overall financial resources, the cost in relation to the company's operations, and the impact on business expenses. C. The court will determine undue hardship solely based on the employer's subjective financial concerns. D. The court will deny the accommodation request if similar requests have been denied in the past. Answer: B. The court will assess the employer's overall financial resources, the cost in relation to the company's operations, and the impact on business expenses. Explanation: Under the Americans with Disabilities Act (ADA), an employer is required to provide reasonable accommodations unless doing so would impose an undue hardship. The standard for undue hardship is not an arbitrary cost threshold, so is incorrect, but rather case-by-case evaluate several factors, including the nature and cost of the accommodation, the overall financial resources of the employer, the size of the business, number of employees, and structure of operations, the impact of the accommodation on business expenses and resources. Because the law does not allow employers to rely on subjective financial concerns, making C incorrect, and because past denials of accommodations do not create precedent for future denials, eliminating D. B is the best answer. The Equal Employment Opportunity Commission (EOC) provides guidance on these considerations, ensuring that businesses cannot refuse accommodations simply due to inconvenience or costs that do not threaten financial viability. Question 2. Topic: Disability rights in healthcare and insurance. Medical decision-making rights. While investigating complicated issue between different healthcare providers, legal dispute arises regarding patient with an intellectual disability. The patient, who has historically made independent medical decisions, is now being denied the ability to refuse high-risk surgery. The hospital argues that the patient's disability impairs their decision ability. The patient's legal representative contests this decision, citing laws on medical decision-making rights. Which legal principle is most relevant in determining whether the patient can refuse the surgery? A. The hospital has the final say in medical decisions for patients with disabilities. B. Court must automatically appoint guardian for any disabled person making medical decision. C. Individuals with disabilities retain the right to make medical decisions unless legal process deems them incapacitated. D. The Americans with Disabilities Act (ADA) automatically protects all disabled individuals from medical procedures. Answer: C. Individuals with disabilities retain the right to make medical decisions unless the legal process deems them incapacitated. Explanation: The right to refuse medical treatment is a fundamental principle in U.S. healthcare law. Under medical decision-making laws, individuals, including those with disabilities, retain the right to make decisions about their health care unless court has determined that they are legally incapacitated. Is incorrect because hospitals do not have unilateral authority to override patient autonomy. B is incorrect because court does not automatically appoint guardians for individuals with disabilities unless evidence shows incapacity. D is incorrect because ADA prevents discrimination but does not itself grant absolute protection against medical procedures. Relevant legal doctrines include informed consent, supported decision-making, and guardianship laws as recognized in cases such as Cruzan v. Director, Missouri Department of Health, 1990. The Unconvention on the Rights of Persons with Disabilities (CED) also emphasizes that individuals with disabilities should retain autonomy in healthcare decisions whenever possible. Question 3. Topic: Technology, digital access, and disability rights. Web accessibility standards during major transformation where existing methods of online service delivery are being updated. Company develops new website but does not include accessibility features for visually impaired users. Disability rights advocacy group files complaint arguing that the company is in violation of accessibility laws. The company responds that as per business it is not legally required to make its website accessible. How would courts likely evaluate this claim under federal law? A. Private companies are exempt from digital accessibility requirements unless they receive federal funding. B. The company must comply with digital accessibility laws if it is classified as a place of public accommodation under EDIT Title Omen 3. Website accessibility is voluntary and businesses can choose whether to adopt accessibility standards. D. Courts cannot enforce digital accessibility laws unless Congress passes new legislation. Answer: B. The company must comply with digital accessibility laws if it is classified as a place of public accommodation under EDIT Title Rome 3. Explanation: under Title Rome 3 of the Americans with Disabilities Act, ADA, businesses that serve the public, such as retail stores, banks, hotels, and online service providers, are considered places of public accommodation and are required to provide equal access to individuals with disabilities. Is incorrect because EDIT Title Rome applies to public accommodations regardless of whether they receive federal funding. C is incorrect because courts have consistently ruled that businesses must comply with accessibility requirements. D is incorrect because existing regulations and case law allow courts to enforce digital accessibility requirements. Web Content Accessibility Guidelines (UEG) and Section 508 of the Rehabilitation Act establish digital accessibility standards, which courts have referenced in cases such as Robles v. Domino's Pizza LLC 2019. The Department of Justice (DOJ) has also reinforced that websites offering public services must comply with ADA requirements to ensure equal access. Question 4. During a critical transition period where existing processes must be adapted to new legal standards, a state agency overseeing public transit systems implements a new accessibility policy to comply with the Americans with Disabilities Act, ADA. However, the new policy includes a provision stating that paratransit services will only be available to individuals with disabilities during non-peak hours, citing an undue burden, increased ridership during rush hours. An advocacy group challenges the policy, arguing that it violates TIA Omen 3, which mandates equal access to public services. The agency defends its decision, claiming the policy is justified under the fundamental alteration exception. Which of the following best explains whether the transit agency's policy is legally valid? A. The policy is valid because TIA Omen allows agencies to restrict accessibility when doing so helps maintain efficient operations. B. The policy is invalid because ADA regulations require that paratransit services be comparable to fixed-route transit systems in all operational hours. C. The policy is valid because agencies are permitted to impose restrictions as long as they do not completely deny services to disabled individuals. D. The policy is invalid because all forms of public transportation must be fully accessible at all times, regardless of costs or operational challenges. Answer: B. The policy is invalid because ADA regulations require that paratransit services be comparable to fixed-route transit systems in all operational hours. Explanation: under Title Roman 2 of the DA, public entities must ensure that individuals with disabilities receive equal access to public services, including transportation. 49C. F. SS 37.131 explicitly requires that paratransit services provide the same hours and days of service as fixed-route services. The agency's restriction of paratransit services during peak hours directly contradicts this requirement. YA is incorrect. While agencies must consider operational efficiency, they cannot impose blanket restrictions that reduce accessibility below required standards. YC is incorrect. An undue burden and a fundamental alteration of defenses apply to extreme circumstances and must be narrowly tailored. Simply citing increased ridership does not meet this threshold. YD is incorrect. While accessibility is required, the law allows for some modifications if they do not substantially limit access beyond ADA's minimum standards. This case highlights the importance of understanding reasonable accommodations and statutory obligations of the ADA when making policy changes. Question 5. When dealing with a complex system that shows occasional failures in providing equal access to services, a state university implements a new digital learning platform for students. However, several blind students file complaints stating that the platform lacks proper screen reader compatibility, making it impossible for them to complete assignments. The university argues that since the platform offers alternative formats for materials and allows professors to provide verbal descriptions, it meets Section 504 of the Rehabilitation Act requirements for accessibility. The students counter that these adjustments do not provide them with an equal educational experience. Under disability law, what is the university's legal responsibility in this case? A. The university is in compliance because it provides alternative ways for blind students to access information. B. The university is violating the law because Section 504 requires equal access to educational materials, not just alternative formats. C. The university is not required to change its digital platform because it offers a general education experience that is inclusive to most students. The university is exempt from accessibility requirements since private vendors, not the university, designed the platform. Answer: B. The university is violating the law because Section 504 requires equal access to educational materials, not just alternative formats. Explanation: Section 504 of the Rehabilitation Act 29 U.S.C. SS 794 mandates that federally funded educational institutions must ensure accessibility for students with disabilities. Digital learning tools must be accessible at the same level of functionality as those available to non-disabled students. YA is incorrect. Offering some accessible materials does not fulfill the requirement of equal access. YC is incorrect. Inclusion of most students does not non-compliance with federal disability laws. YD is incorrect. Institutions are responsible for ensuring that third-party vendors comply with accessibility laws. Takeaway: compliance with digital accessibility laws, including Section 508 and Web Content Accessibility Guidelines (WCAG 2.1), is critical in education. Question 6. In a high-stakes environment where multiple challenges must be balanced, an employer faces an issue where a deaf employee requests a full-time sign language interpreter for all meetings. The employer argues that providing such an accommodation is an undue hardship due to costs and operational difficulties. The employee claims that without an interpreter, they are excluded from critical discussions and unable to perform their duties effectively. The employer, instead to provide summarized written transcripts after each meeting, under the ADA is the employer required to provide a real-time sign language interpreter. A yes, because real-time communication is essential for full participation in the workplace. B, no, because summarized written transcripts provide an alternative form of access. C, yes, but only if the employee can prove that the lack of an interpreter makes them unable to complete essential job functions. D, no, because the ADA allows employers to balance accommodations with financial limitations. Answer: A, yes, because real-time communication is essential for full participation in the workplace. Explanation: the ADA, Title I, 42 U.S.C. SS 12111 requires employers to provide reasonable accommodations unless they impose an undue hardship. Courts have ruled that real-time interpreters are necessary accommodations for deaf employees in workplace settings where active participation is required. EOC v. FedEx Ground Package System Inc. 2014. Y. B is incorrect. Summarized transcripts do not provide equal real-time participation. C is incorrect. The law presumes an accommodation is reasonable unless the employer proves otherwise. Y. D is incorrect. Financial hardship must be significant and well documented to exempt an employer from ADA compliance. Takeaway: employers must engage in the interactive process under 29 CFR SS 1630.2 to determine appropriate accommodations. Question 7. During a critical transition period where existing processes must adapt to new legal standards, a national retail chain updates its website to improve digital accessibility. However, after the update, a group of visually impaired customers files a complaint stating that key elements such as product descriptions and checkout processes are not compatible with screen readers. The company argues that it has made reasonable modifications, that fixing all remaining accessibility issues would require a significant financial investment, constituting an undue burden. Under the Americans with Disabilities Act (ADA) and relevant case law, is the company's defense legally valid? A, yes, because the company has already made efforts to improve accessibility, which is sufficient. B, no, because Title Roman of the ADA requires businesses to ensure full and equal enjoyment of their online services. C, yes, because private businesses are not required to make every digital feature 100% accessible. D, no, because financial hardship is never an acceptable defense under the ADA. Answer: B, no, because Title Roman of the ADA requires businesses to ensure full and equal enjoyment of their online services. Explanation: Title Roman of the ADA, 42 U.S.C. SS 12182 mandates that places of public accommodation, including websites, must provide equal access to individuals with disabilities. The Department of Justice Dudgett and multiple court rulings e.g. Gill v. Winn-Dixie 2021 have reinforced that digital barriers preventing equal access violate the ADA. YA is incorrect. Partial compliance does not satisfy the full and equal enjoyment. The standard YC is incorrect. The ADA does not require absolute perfection, but it does require businesses to remove barriers unless doing so is an undue burden, which must be proven. YD is incorrect. Financial hardship can be defense in extreme cases, but it must be well documented and proportionate to the overall financial resources of the business. This case underscores the growing importance of digital accessibility under the WA 2.1 compliance. Question 8. In a situation where formal requirements conflict with operational limitations, a hospital implements a policy requiring all nurses to work 12-hour shifts, citing efficiency and patient care needs. However, a nurse with multiple sclerosis (MS) requests a modified schedule with short shifts as a reasonable accommodation under the ADA. The hospital denies the request, arguing that all nurses must follow the same schedule to maintain consistency in patient care. Under the ADA, does the hospital's decision comply with disability law? A. Yes, because uniform scheduling is an essential job function in hospital setting. B. No, because the ADA requires employers to provide reasonable accommodations unless it causes an undue hardship. C. Yes, because healthcare workers have different legal standards under disability law. D. No, because the hospital is required to eliminate all barriers for employees with disabilities. Answer. B. No, because the ADA requires employers to provide reasonable accommodations unless it causes an undue hardship. Explanation. Under Title I of the ADA 42 U.S.C. SS 12111, employers must provide reasonable accommodations to employees unless doing so would impose an undue hardship. Courts have ruled that modifying work schedules is common and reasonable accommodation. EOC v. Up Supply Chain Solutions 2021. YA is incorrect. While consistency is important, employers must still assess whether flexible scheduling is feasible. YC is incorrect. Healthcare workers are not exempt from ADA protections. YD is incorrect. Employers are not required to eliminate all barriers, but they must make reasonable efforts to accommodate. Key takeaway. Flexible scheduling can be reasonable accommodation and must be evaluated on case-by-case basis. Question 9. When developing a solution that must address opposing needs, a university professor with generalized anxiety disorder requests to work remotely as a reasonable accommodation under the ADA. However, the university argues that in-person instruction is an essential job function and denies the request. The professor claims that virtual instruction has been widely used and that other professors are teaching hybrid classes. Under the ADA, is the university required to grant the remote work accommodation? Yes, if the university allows some faculty to work remotely, it must extend the same option to all employees with disabilities. B. No, because the university has the right to define essential job functions and require in-person teaching. C. Yes, if remote work does not fundamentally alter the professor's ability to perform job duties. D. No, because mental health conditions do not qualify for accommodations under the ADA. Answer. C. Yes, if remote work does not fundamentally alter the professor's ability to perform job duties. Explanation. Under the ADA, employers must engage in an interactive process to determine if remote work is reasonable accommodation. EOC v. Ford Motor Company 2015. YA is incorrect. Employers are not required to provide identical accommodations to all employees, but they must evaluate individual cases fairly. B is incorrect. Essential job functions must be evaluated objectively, and if teaching can be done remotely, denial may not be justified. YD is incorrect. Mental health conditions qualify for accommodations under the ADA if they substantially limit one or more major life activities. This case highlights how remote work accommodations must be assessed based on actual job requirements, not just historical precedent. Question 10. In a high-stakes environment where multiple challenges must be balanced, a law enforcement agency updates its fitness for duty policy, requiring all officers to pass an annual physical agility test. An officer with a mobility disability who has performed desk duties for years fails the test and is placed on unpaid leave. The officer argues that the test is not relevant to their job duties and requests a waiver as a reasonable accommodation. Agency legally required to waive the physical test? Yes, because the officer's current duties do not require full agility. B. No, because law enforcement agencies are exempt from the ADA's reasonable accommodation requirements. C. Yes, because Title I of the ADA prohibits discriminatory fitness standards. D. No, if the test is job-related and consistent with business necessity. Answer D. No, if the test is job-related and consistent with business necessity. Explanation. Under Title I of the ADA 42 U.S.C. SS 12,113 employers may impose fitness standards if they are job-related and necessary for the role. Courts have ruled that public safety positions may require certain physical abilities. Albertsons Inc. v. Kirkenberg, 1999. YA is incorrect. The agency must assess whether the officer's current role truly requires physical agility. YB is incorrect. Law enforcement agencies must comply with the ADA. YC is incorrect. The ADA allows fitness standards if they are directly job-related. This case demonstrates the business necessity of defense under disability law. Question 11. When implementing new protocols in a shared environment, a large corporate office introduces a flexible seating policy where employees no longer have assigned desks. An employee with severe arthritis requests an ergonomic chair and a fixed workstation as a reasonable accommodation under the ADA. The company denies the request, arguing that the new policy applies to everyone equally and that making exceptions would be unfair. Under the ADA, is the company legally required to provide an accommodation? A. Yes, because the ADA requires reasonable accommodations even if a policy applies uniformly to all employees. B. No, because company-wide policies override individual accommodation requests. C. Yes, but only if the employee can prove that their condition is severe enough to justify the request. D. No, because offering a fixed workstation would create preferential treatment rather than equal access. Answer A. Yes, because the ADA requires reasonable accommodations even if a policy applies uniformly to all employees. Explanation. The ADA, Title I, 42 U.S.C. SS 12,112 B5A requires employers to make reasonable accommodations unless it would impose an undue hardship. Company-wide policies do not override the obligation to accommodate qualified individual. Y. B is incorrect. The ADA takes precedence over general workplace policies. YC is incorrect. Employees are not required to prove severity, only that their disability substantially limits life activity. YD is incorrect. The purpose of accommodations is to ensure equal access, not to provide an unfair advantage. This case underscores that accommodations may override uniform workplace policies if necessary. Question 12. During a comprehensive review of a process that needs improvement, a government agency evaluates its hiring practices and discovers that its written job exam disproportionately disqualifies applicants with dyslexia. A candidate who failed the exam files a complaint, arguing that the agency failed to offer alternative testing formats. Under the ADA, is the agency required to modify the test for applicants with dyslexia? A. Yes, because employers must provide reasonable testing accommodations unless it alters the nature of the assessment. B. No, because modifying a standardized test would create an unfair advantage. C. Yes, because all applicants must be treated equally regardless of disability. D. No, because public sector employers are exempt from ADA testing accommodation requirements. Answer A. Yes, because employers must provide reasonable testing accommodations unless it alters the nature of the assessment. Explanation. The ADA, Title I, 42 U.S.C. SS 12,112 B7 requires employers to offer reasonable accommodations in hiring processes, including modifications to exams. The EOC and Case Law E.g. Bartlett v. NY State Board of Law Examiners, 1999, reinforced that individuals with dyslexia must be given alternative formats, e.g. extra time oral exams. B is incorrect. Providing accommodations does not create an unfair advantage. It levels the playing field. C is incorrect. Treating all applicants the same does not mean treating them fairly under disability law. D is incorrect. Public employers are not exempt from ADA hiring requirements. This case highlights how reasonable accommodations must be considered in hiring and testing environments. Question 13. While analyzing the root causes of sequential problems in workplace injuries, a manufacturing plant notices a higher injury rate among employees with hearing impairments, particularly near moving machinery. The company considers reassigning these employees to different roles even if they have not requested it. Under the ADA, can the company legally reassign employees with hearing impairments without their consent? A. Yes, if the company believes it is necessary for safety reasons. B. No, because reassignment based on disability without consent can be discriminatory. C. Yes, because workplace safety takes precedence over individual rights under the ADA. D. No, unless the employees fail to meet essential safety standards after being given reasonable accommodations. Answer: D. No, unless the employees fail to meet essential safety standards after being given reasonable accommodations. Explanation: the ADA prohibits involuntary reassignment based solely on disability unless reasonable accommodations have been attempted and safety concerns remain. Courts have ruled that employers must engage in an interactive process before transferring employees. Chevron v. Etchezabal, 2002. YA is incorrect. Employers cannot assume that an employee is unsafe without assessing their abilities. YB is incorrect. Automatic reassignment without dialogue may violate the ADA. YC is incorrect. Safety matters, but employers must first attempt reasonable accommodations. This case demonstrates the balance between workplace safety and disability rights. Question 14. In a multi-location scenario where consistency requirements must be maintained, a nationwide hotel chain updates its customer service protocols, requiring all front desk employees to answer phone calls as part of their duties. A deaf employee requests an alternative task, arguing that handling calls is not feasible. Under the ADA, must the employer grant this accommodation? A. Yes, because the ADA allows job duty modifications if they do not fundamentally alter the role. B. No, because customer service duties require uniformity across locations. C. Yes, but only if the employee has been with the company for more than 1 year. D. No, because allowing an alternative task would disrupt business operations. Answer: A. Yes, because the ADA allows job duty modifications if they do not fundamentally alter the role. Explanation: the ADA, Title I, 42 U.S.C. SS 12111 requires employers to provide accommodations unless it fundamentally alters the job or creates an undue hardship. Courts have upheld that redistributing minor tasks may be reasonable accommodation. EOC v. Converges, 2007. YB is incorrect. Uniformity does not outweigh ADA compliance. YC is incorrect. ADA accommodations do not depend on tenure. YD incorrect. Minor task adjustment does not necessarily disrupt operations. This case highlights how job duty modifications must be evaluated for reasonableness. Question 15. During an emergency response where multiple areas are impacted, a hospital implements a rapid evacuation plan during a natural disaster. A wheelchair user expresses concerns that the current staircase-only exit plan does not accommodate individuals with mobility impairments. Under the ADA, what should the hospital do? A. Require the employee to sign a liability waiver acknowledging the risks involved. B. Provide a reasonable accommodation such as an evacuation chair or designated staff assistance. C. Advise the employee to remain in a designated safe zone until the emergency passes. D. Maintain the current evacuation plan as emergency procedures are exempt from ADA compliance. Answer: B. Provide a reasonable accommodation such as an evacuation chair or designated staff assistance. Explanation: either to AM and to public hospitals, Title Roman for private facilities requires equal access in emergency preparedness. The Department of Justice guidelines state that reasonable accommodations must be made for individuals with disabilities in emergency evacuations. YA is incorrect, requiring does not remove the hospital's legal responsibility. YC is incorrect. Safe zone approach does not ensure equal safety access. YD is incorrect. Emergency procedures must comply with accessibility laws. This case highlights ADA-compliant emergency preparedness and inclusivity in crisis planning. Question 16. In a situation where formal requirements conflict with accessibility needs, an airline requires all passengers to be able to exit the aircraft independently in case of an emergency. A blind passenger with a service dog is denied boarding as the airline argues that the passenger may need assistance during evacuation. Is this denial legal under the Air Carrier Access Act? A. Yes, because safety regulations take precedence over disability laws. B. No, because airlines must provide reasonable accommodations and cannot impose blanket restrictions. C. Yes, if the airline believes that the passenger poses a direct safety threat. D. No, because all passengers are equally capable of evacuating regardless of ability. Answer: B. No, because airlines must provide reasonable accommodations and cannot impose blanket restrictions. Explanation: the Air Carrier Access Act, 14 CFR Part 382, prohibits discrimination against passengers with disabilities. Airlines cannot impose general restrictions without an individualized safety assessment. YA is incorrect. Safety regulations must align with disability laws. Why C is incorrect. Airlines must assess each passenger's ability case by case, not assuming capacity. Why D is incorrect. Not all passengers evacuate the same way, but accommodations ensure equal access. This case highlights the balance between safety and disability rights in travel. Question 17. When improving a process that shows unexpected results, a software company introduces mandatory eye tracking technology for employees working remotely to ensure productivity. An employee with a neurological condition that affects eye movement requests an alternative tracking method. What should the employer do under the ADA? A. Deny the request, as performance monitoring is a business necessity. B. Offer an alternative tracking method as a reasonable accommodation. C. Require the employee to provide medical proof that the technology is harmful. D. Terminate the employee if they cannot comply with the tracking policy. Answer B. Offer an alternative tracking method as a reasonable accommodation. Explanation. The ADA prohibits discriminatory workplace policies and requires reasonable accommodations for monitoring methods. Employers must explore alternative solutions if technology creates undue barriers. YA is incorrect. Business policies cannot override disability rights. YC is incorrect. Employers may ask for medical documentation but delay accommodations. YD is incorrect. Terminating an employee for a disability-related issue may be discriminatory. This case highlights how technology policies must accommodate disabilities under the ADA. Question 18. While examining inconsistencies across various units, a federal agency realizes that its electronic records system is inaccessible to employees using screen readers. Several employees with visual impairments file a complaint. What legal standard applies in this situation? A. Section 504 of the Rehabilitation Act, which requires accessibility for federally funded programs. B. Tithomon to the IDA, which mandates that all workplaces use accessible technology. C. The Fair Labor Standards Act, which regulates workplace conditions. D. There are no legal requirements for technology accessibility in government workplaces. Answer A. Section 504 of the Rehabilitation Act, which requires accessibility for federally funded programs. Explanation. Section 504 of the Rehabilitation Act 29 U.S.C. SS 794 requires federal agencies and recipients of federal funds to ensure equal access to digital resources. B is incorrect. Tithomon applies to state and local governments, but federal agencies fall under Section 504. YC is incorrect. The FLSA regulates wages and hours, not accessibility. YD is incorrect. Federal workplaces must comply with digital accessibility laws. This case highlights the importance of accessible technology in public sector employment. Question 19. In a case where multiple parties have different objectives, a corporate building hires an external cleaning service. One of the janitors, who has severe asthma, requests a transfer away from high chemical areas, but the cleaning company refuses, citing equal work distribution policies. Does the ADA require the company to grant this request? A. Yes, because accommodations must be considered even for third-party contractors. B. No, because independent contractors are not covered by the ADA. C. Yes, but only if the employee can show a doctor's note confirming their asthma. D. No, because work policies must be uniform across all employees. Answer A. Yes, because accommodations must be considered even for third-party contractors. Explanation. The ADA, Title I, 42 U.S.C. SS 12,111 (5) applies to contracted employees if the employer exercises control over work conditions. B is incorrect. Contract workers may still qualify for accommodations. C is incorrect. Employers can request medical documentation but cannot deny the request outright. D is incorrect. Uniform policies must allow case-by-case accommodations. This case highlights how the ADA applies. Third-party employment relationships. Question 20. During a seamless transition where continuity must be maintained, a large law firm implements a new billing software that is incompatible with assistive technology used by an attorney with low vision. The attorney requests an alternative solution. How should the employer respond under the ADA? A. Provide an alternative that ensures the attorney can perform essential job functions. B. Deny the request, as software updates are a business priority. C. Require the attorney to find their own solution. D. Offer a leave of absence instead of modifying the software. Answer A. Provide an alternative that ensures the attorney can perform essential job functions. Explanation: the ADA, Title I, 42 U.S.C. SS 12112 B5 mandates reasonable accommodations, including software modifications. Why B is incorrect. Business priorities cannot override accessibility. Why C is incorrect. The burden is on the employer, not the employee. Why D is incorrect. Leave is not substitute for accommodations. This case highlights the importance of accessible workplace technology. Question 21. During a compliance review that requires urgent resolution, a retail store's online job application system is found to be inaccessible to applicants with visual impairments. Complaint is filed under the ADA. What is the company required to do? A. Provide an alternative application process, such as phone-based applications. B. Defend the existing system, as online platforms are not covered under the ADA. C. Require visually impaired applicants to seek assistance from sighted person. D. Remove the job posting entirely until the issue is resolved. Answer: A. Provide an alternative application process, such as phone-based applications. Explanation: Title I of the ADA requires that job application processes be accessible to individuals with disabilities. Failure to provide accessible technology may constitute discrimination. Why B is incorrect. The ADA applies to hiring platforms, including online applications. Why C is incorrect. Employers must provide reasonable accommodation, not shift responsibility to applicants. Why D is incorrect. Removing the job posting does not address accessibility concerns. This case highlights the importance of inclusive hiring practices under the ADA. Question 22. When evaluating policies that may have unintended consequences, a university requires students to attend mandatory in-person exams. A student with severe social anxiety disorder requests to take the exam in a private setting as an accommodation. What should the university do under the ADA? A. Deny the request, as all students must follow the same policies. B. Allow the student to take the exam in an alternate setting, such as a private room. C. Require the student to provide a detailed personal statement explaining their anxiety. D. Exempt the student from the exam entirely. Answer: B. Allow the student to take the exam in an alternate setting, such as a private room. Explanation: Tenement of the requires public universities to provide reasonable accommodations unless they create undue burden or fundamentally alter the program. Why A is incorrect. The university must offer accommodations for disabilities. Why C is incorrect. While documentation may be required, a personal statement alone is sufficient. Why D is incorrect. Exempting the student could alter the course requirements unfairly. This case highlights educational accommodations under the ADA. Question 23. While monitoring changes that affect various stakeholders, a city installs new parking meters that require touchscreen interaction. A group of individuals with visual impairments files a complaint. Which law applies in this case? A. The Fair Housing Act, which regulates accessibility in public spaces. B. Title II of the ADA, which applies to state and local government services. C. The Rehabilitation Act, which only applies to federal agencies. D. There are no legal requirements for accessible parking meters. Answer: B. Title of the ADA, which applies to state and local government services. Explanation: Title II of the ADA requires public services and facilities to be accessible to individuals with disabilities. Why A is incorrect. The Fair Housing Act applies to housing, not public services. Why C is incorrect. The Rehabilitation Act applies to federal programs, not city governments. Why D is incorrect. ADA compliance is required. Public infrastructure. This case highlights the importance of accessible city planning. Question 24. When analyzing disputes over reasonable accommodations, a call center requires employees to work long hours in front of computer screens. An employee with chronic migraines requests regular screen breaks as an accommodation. What should the employer do under the ADA? A. Grant the request unless it creates undue hardship. B. Deny the request, as all employees must work the same hours. C. Require the employee to use personal sick leave for breaks. D. Offer the employee a lower-paying role instead. Answer: A. Grant the request unless it creates undue hardship. Explanation: Title I of the ADA requires employers to provide reasonable accommodations that do not create undue hardship. Why B is incorrect. Equal treatment does not mean denying accommodations. Why C is incorrect. Accommodations should not reduce employee benefits. Why D is incorrect. Demotions are not a substitute for reasonable accommodations. This case Workplace accommodations for chronic health conditions. Question 25. During an investigation into accessibility complaints, a hotel chain is found to lack wheelchair-accessible guest rooms. Which law applies in this case? A. Tidde Romerthe of the Edda, which governs public accommodations. B. The Rehabilitation Act, which applies only to federal buildings. C. OSHA regulations, which focus on workplace safety. D. The Fair Housing Act, which applies only to residential properties. Answer: A. Title Romanth of the Edda, which governs public accommodations. Explanation: Title Romanth of the Edda requires public businesses, including hotels, to provide equal access. Why? B is incorrect. The Rehabilitation Act does not apply to private hotels. Why? C is incorrect. OSHA focuses on employee safety, not guest accessibility. Why? D is incorrect. The Fair Housing Act covers rental housing, not hotels. This case highlights compliance in hospitality. Question 26. When implementing new workplace policies that affect employees with disabilities, an office switches to voice command-only computers. An employee with a speech impairment requests a keyboard alternative. What should the employer do? A. Provide a keyboard as a reasonable accommodation. B. Require the employee to adapt to the new system. C. Offer the employee a non-computer-based role instead. D. Deny the request, as technology changes must apply uniformly. Answer: A. Provide a keyboard as a reasonable accommodation. Explanation: The ADA requires that workplace technology changes do not exclude employees with disabilities. Why? B is incorrect. Employees cannot be forced to use inaccessible technology. Why? C is incorrect. Reassigning the employee is not a reasonable first step. Why? D is incorrect. Uniform policies must allow accommodations. This case highlights accessible work technology policies. Question 27. When assessing financial costs against accessibility improvements, a small business argues that installing a wheelchair ramp would be too expensive. What does the ADA require? A. The business must install the ramp unless it causes undue hardship. B. The business is exempt because of financial constraints. C. The business can deny access to customers with mobility impairments. D. The business can charge a fee for accessible entry. Answer: A. The business must install the ramp unless it causes undue hardship. Explanation: Title Romanth of the ADA requires businesses to make reasonable modifications unless costs are prohibitive. Why? B is incorrect. Financial concerns do not automatically grant exemptions. Why? C is incorrect. Discriminatory policies violate the ADA. Why? D is incorrect. Charging extra for accessibility is unlawful. This case highlights the balance between cost and compliance. Question 28. While analyzing the root causes of sequential problems in a restaurant chain, it is discovered that its digital ordering system is inaccessible to customers with visual impairments. A customer files a complaint under the ADA. What is the restaurant required to do? A. Ensure the digital ordering system is compatible with screen readers. B. Offer discounts to visually impaired customers as compensation. C. Require visually impaired customers to place orders in person. D. Disable the online ordering system until accessibility issues are resolved. Answer: A. Ensure the digital ordering system is compatible with screen readers. Explanation: Title Romanth of the ADA requires businesses that serve the public to make their digital platforms accessible. Why? B is incorrect. Compensation does not replace legal compliance. Why? C is incorrect. Customers must have equal access to services. Why? D is incorrect. Shutting down the system does not address accessibility. This case highlights digital accessibility in commercial services. Question 29. When implementing new protocols in a shared environment, an airport introduces self-service check-in kiosks that lack accessibility features for passengers with limited mobility and visual impairments. Which action would best align with ADA compliance? A. Providing an alternative method, such as staffed check-in counters. B. Requiring passengers with disabilities to bring an assistant. C. Offering discounts to passengers who cannot use the kiosks. D. Removing the kiosks entirely. Answer: A. Providing an alternative method, such as staffed check-in counters. Explanation: Title Romanth of the EDA applies to public accommodations, including airports. Alternative service options must be available when self-service technology is not fully accessible. Why? B is incorrect. The burden cannot be placed on passengers. Why? C is incorrect. Financial compensation is not a substitute for accessibility. Why? D is incorrect. Removing technology does not resolve accessibility issues. This case highlights the role of alternative service methods under ADA guidelines. Question 30. During a major transformation where existing methods are being updated, a corporate office replaces all its communication platforms with voice-only messaging software. An employee with hearing impairment requests an alternative method, such as text-based communication. What is the employer's responsibility under the ADA? They provide a text-based alternative, such as instant messaging or email. B. Require the employee to rely on coworkers for communication. C. Offer the employee a new position where voice communication is not required. D. Maintain the voice-only system and offer training on lip reading. Answer: A. Provide a text-based alternative, such as instant messaging or email. Explanation: Title I of the ADA requires employers to provide reasonable accommodations to employees with disabilities. A text-based option is a reasonable adjustment for an employee with hearing impairment. Why B is incorrect. Employees must have independent access to communication. Why C is incorrect. Reassigning the employee is not the first solution. Why D incorrect. Forcing an employee to adapt instead of modifying tools violates ADA guidelines. This case highlights the importance of workplace communication accessibility.